Welcome back to Florida Realtors live stream. I'm your host, Tracy Velt. I am a contributing editor of Florida Realtor Magazine and host of the Housing Wire's Real Trending podcast, where I interview top agents, teams, and executives on building a better business. Today, I am talking to Juana Watkins. She is the General Counsel and Vice President of Law and Policy for Florida Realtors. So welcome, Juana.
Thank you so much, Tracy. It is a pleasure to be here with you all today.
So we're going to start with top three issues. You hear from all the legal hotline attorneys. What are you hearing the most right now?
Yeah, Tracy, I love our legal hotline. I mean, I call it the real-time information gathering service of Florida Realtors. 70,000 plus phone calls and emails a year from our members.
Amazing.
Top three, we're talking contract issues all the time. That dominates every single list that we create, and we do so quarterly, by the way.
Yes.
Contract issues, formation questions, calculation of time, right?
Yeah.
Some of these more basic contract issues still trip up some of our members, and it's not surprising. I looked at the Florida Real Estate Commission stats, over 1,800 new agents last month, right?
Yeah.
That's a lot. And so the basics, formation, calculation of time, and then there are the more complicated contract issues, financing and things like that are always on the list. But beyond contract issues, we're seeing a lot with disclosure. When do I have to tell them that there is a hole in the roof, or my seller doesn't want me to disclose that there's a hole in the roof? So all of these different disclosure type issues typically will dominate the calls, and we want that because these are factually driven calls that we have to really get into the details of with the members. And I'd say kind of the last one, usually things where there is just a general, I would call it legal dispute between the parties, right? Something has gone wrong in the transaction, or sometimes something has gone wrong between the broker and the agent, independent contractor disputes and questions. So just those general, what are my rights types of questions, we get a lot of.
Yeah, definitely. And so with the kind of post-Surfside legislative changes, 4 major bills in, I think, 4 years. So what's your best guidance for realtors to stay compliant and proactive, especially as more statutory deadlines and form updates roll out now?
Yeah, I mean, this is the condo shifting sands, as I call it, Tracy. That is the prime example of where it is so important for members to engage with their law and policy resources. We have done webinars. We have done articles, frequently asked questions, all of those things to try to help the members stay current on those shifting sands. It is difficult and complicated. I work a lot with the attorneys at the Florida Bar, real property attorneys, and we struggle sometimes to really get our arms around the changes and the sometimes unintended consequences of those changes and how we're going to actually apply them in practice on the legal side. And it's no different on the real estate practice side, right? They've got to avail themselves of those resources. If they're not reading the legal news, now's the time to start.
Yes.
If they're not visiting that library for those frequently asked questions, now's the time to start. So we're going to continue to roll out resources because we're hearing from the members how difficult it still is to interact with condo associations and with their customers, quite frankly, to understand what is a SIRS, what is a milestone inspection report. This is not normal lingo for the average homeowner and home buyer. So we need them to engage with us on those questions and those issues.
And what do you see as like maybe the top issue that agents are confused with right now?
When is the SIRS and the milestone inspection report required?
Yeah.
Right? And it's even more complicated because when you start to get into some of the, I always say with this legal stuff, many layers, many players. And condos is one of those areas.
Yeah.
So we're still seeing a lot of confusion because even though the legislature has, in Condo 4.0, clarified some issues, there's still county-specific requirements in terms of the age of the building and this number of stories and when these laws apply. And so it can get really complicated sometimes for them to understand. So we have updated all of our forms to make sure they have a really good kind of roadmap and a detailed explanation in the condo addendum and condo rider to understand when it applies. But even there, it's very difficult because, again, this is not language that the average Florida citizen is going to understand.
Yeah, and it's definitely important, members, to understand there's tons of information available on floridarealtors.org. And if there's any confusion, call the legal hotline.
Absolutely.
Great resource. So let's talk about particular contract provisions, especially in the FAR bar as-is contract, that are kind of leading to more disputes or questions.
Yeah, definitely. We talked about condo, right?
Yes.
Updating those condo forms, making sure those were rolled out. I would say that the two that I think cause the most consternation, financing, right? Financing, what is a property-related condition? I don't think they really tried to get the loan. What is due diligence with respect to the loan approval process? We get tons of calls about the financing clause of the contract. And so, again, though, those are really factually driven types of analysis that we really want to talk the member through, right? Break out that contract, break out that language, and walk them through, because every buyer is going to be a little bit differently situated in terms of the loan that they're applying for and how long they had to apply and what type of property-related conditions the lender is imposing. So we really need them to call us so we can walk them through that. Inspection period's another one. The FAR bar as-is contract is, without a doubt, the most commonly used contract in the state. But what we're starting to see, especially as we shift to a little bit more of a buyer's market, is folks getting a little creative with the language, right? Well, it's as is, but we now want the seller to make some repairs, right? Can't we ask the seller? Well, you can. Is the seller obligated? That was a completely different analysis, right? Because you chose an as-is contract to use to write your offer. So that kind of post-inspection, now how do we move forward now that I've found something I don't like, but I want to keep the property, is causing quite a few calls into the hotline.
Yeah. Do you think that they should be using a different contract rather than the as-is?
And that's something I think that some folks might take for granted. I say which form you use is as negotiable a tool or a term as price and closing date and all of those things. You really have to think through, what am I hoping to accomplish here? And after you see that property, if you have some concerns that perhaps there may be some physical issues that you find less than desirable that you might actually want to have the seller repair, maybe an as-is contract is not the contract you want to use to convey your offer. But then again, maybe not. And so there are options available to that buyer and that buyer's agent, and I think that's one of the things they need to talk through.
Okay, great. Well, we're 1 year past the settlement, the famous settlement.
Yes, we are.
Are you getting a lot of questions still on the legal hotline? And what is the biggest source of confusion to members? When
to use compensation agreements, which compensation agreements to use. All of those things continue to generate calls into the hotline, and we want those calls. We'd rather they get it right? So the compensation piece is still confusing, right? And what we try to do is roll out a system to help them make that pivot to the new way of doing business. And for the most part, we think they have received it well. But every now and then we'll hear from a broker who says, my agent didn't get it right, and now I'm obligated to pay some commission that I may not have otherwise been obligated to pay.
Yeah.
And so we do recognize the need to continue to keep our foot on the gas as it relates to training on those settlement-related issues. Again, 1,800 new people into the business last month.
Yeah.
So it's not just renewing education for folks, it's also teaching new people who came into this business since the settlement became final.
Yeah, absolutely. I think that, that compensation piece is especially for people who've been in the business for a long time and have done it a certain way for years, realizing now that you have to negotiate that.
Right.
And it's not with the seller or the seller's agent, it's with your own buyer first. And so it gets confusing.
Value proposition, right?
Yep.
Like more than ever before, we know the value of using a realtor. You got to communicate it, and explain why that buyer representation agreement is being put in front of that buyer.
Yeah.
And I think as we become more and more effective at that, right, more and more comfortable with that, I think it'll be a lot less intimidating for most of our members.
Yeah.
And I think buyers will receive it well.
Yeah. Final question. What's one piece of advice you have for agents today?
Those that train remain, right?
Yep.
And I don't mean that in the sense that you train in such a mandatory way that you threaten independent contractor status, right? Like I hear people say that, can you really train them? I mean those who really engage in the training opportunities like this convention will have better success in this industry. We talked about condo 1.0, 2.0, 3.0, 4.0, flood disclosures, all of these different issues that we are seeing just legislatively, not to mention court cases and case law that we monitor and have to implement. This is a busy time in terms of regulations and laws and things that are changing. We're prepared to help equip them with what they need in order to be successful. We say your success is our business, and we mean that. But we need them to engage with us. Call that hotline, 70,000. That's a lot, but we got capacity for even more, and we want to help them be successful. So now more than ever, we need them to be engaged on the legal changes and on the risk management part of this. I've said it, this is bubble wrap season. People say, well, I'm not as busy as I've been. That's okay. This is a time now to look at what you're doing, not just for efficiencies, but effectiveness and for regulatory compliance. And that's what I want members to be focused on in this time where you may not be closing quite as much as you were 2 years ago.
So for people who are here, when is your next session?
So we have our legal update on, I believe it is Tuesday, our closing session.
Okay.
It's a combination session with Dr. Brad O'Connor and my team, and we are super excited. It is our most ambitious legal update yet. I looked at the PowerPoint, 90 slides in 60 minutes, but we are going to rock and roll and get through because, again, there's so much, Tracy, that we need to put on the members' radar. So I hope they join us because, again, get in there, learn about what's happening so that we can help them insulate their business.
Yeah. So it's at 3 o'clock tomorrow, and definitely attend that session. And thank you, Juana, for answering some of these important legal questions.
Thank you for giving me an opportunity to answer them.
Yes. And for our audience who is out there listening live, we have our next session with Kendall Bonner. It is on creating community, and she does a phenomenal job of taking her social media and her online, offline, and really building those relationships. She's going to talk all about it at 2 o'clock, so join us then.